It is a Latin term which literally means to have the body of. It is an order issued by the court to a person who has detained another person to produce the body of the latter before it. The court then examines the cause and legality of detention. It would set the detained person free if the detention is found to be illegal. Thus, this writ is a bulwark of individual liberty against arbitrary detention. The writ of habeas corpus can be issued against both public authorities as well as private individuals. The writ, on the other hand, is not issued where the a. Detention is lawful, b. The proceeding is for contempt of a legislature or a court, c. Detention is by a competent court, and d. Detention is outside the jurisdiction of the court. Mandamus. It literally means, we command. It is a command issued by the court to a public official asking him to perform his official duties that he has failed or refused to perform. It can also be issued against any public body, a corporation, an inferior court, a tribunal or government for the same purpose. The writ of mandamus cannot be issued, a. Against a private individual or body, b. To enforce departmental instruction that does not possess statutory force, c. When the duty is discretionary and not mandatory, d. To enforce a contractual obligation, e. Against the President of India or the state governors, and f. Against the Chief Justice of a High Court acting in judicial capacity. Prohibition. Literally, it means to forbid. It is issued by a higher court to a lower court or tribunal to prevent the latter from exceeding its jurisdiction or usurping a jurisdiction that it does not possess. Thus, unlike mandamus that directs activity, the prohibition directs inactivity. The writ of prohibition can be issued only against judicial and quasi-judicial authorities. It is not available against administrative authorities, legislative bodies, and private individuals or bodies. Certiorari. In the literal sense, it means to be certified or to be informed. It is issued by a higher court to a lower court or tribunal either to transfer a case pending with the latter to itself or to squash the order of the latter in a case. It is issued on the grounds of excess of jurisdiction or lack of jurisdiction or error of law. Thus, unlike prohibition, which is only preventive, certiorari is both preventive as well as curative. Previously, the writ of certiorari could be issued only against judicial and quasi-judicial authorities and not against administrative authorities. However, in 1991, the Supreme Court ruled that the certiorari can be issued even against administrative authorities affecting rights of individuals. Like prohibition, certiorari is also not available against legislative bodies and private individuals or bodies. Quo warranto. In the literal sense, it means, by what authority or warrant. It is issued by the court to inquire into the legality of claim of a person to a public office. Hence, it prevents illegal usurpation of public office by a person. The writ can be issued only in case of a substantive public office of a permanent character created by a statute or by the Constitution. It cannot be issued in cases of ministerial office or private office. Unlike the other four writs, this can be sought by any interested person and not necessarily by the aggrieved person. Armed Forces and Fundamental Rights. Article 33 empowers the Parliament to restrict or abrogate the fundamental rights of the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous forces. The objective of this provision is to ensure the proper discharge of their duties and the maintenance of discipline among them. The power to make laws under Article 33 is conferred only on Parliament and not on state legislatures. Any such law made by Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. Accordingly, the Parliament has enacted the Army Act, 1950, the Navy Act, 1950, the Air Force Act, 1950, the Police Forces, Restriction of Rights, Act, 1966, the Border Security Force Act and so on. These impose restrictions on their freedom of speech, right to form associations, right to be members of trade unions or political associations, right to communicate with the press, right to attend public meetings or demonstrations, etc. Table 7.3 Martial Law versus National Emergency. Martial Law National Emergency. 1. It affects only fundamental rights. 1. It affects not only fundamental rights but also center-state relations, distribution of revenues and legislative powers between center and states and may extend the tenure of the Parliament. 2. It suspends the government and ordinary law courts. 2. It continues the government and ordinary law courts. 3. It is imposed to restore the breakdown of law and order due to any reason. 3. It can be imposed only on 3 grounds: war, external aggression or armed rebellion. 4. It is imposed in some specific area of the country. 4. It is imposed either in the whole country or in any part of it. 5. It has no specific provision in the Constitution. It is implicit. 5. It has specific and detailed provision in the Constitution. It is explicit. The expression members of the armed forces also covers such employees of the armed forces as barbers, carpenters, mechanics, cooks, chowkidars, bootmakers, tailors who are non-combatants. A parliamentary law enacted under Article 33 can also exclude the court-martial, tribunals established under the military law, from the writ jurisdiction of the Supreme Court and the High Courts, so far as the enforcement of fundamental rights is concerned. Martial law and fundamental rights. Article 34 provides for the restrictions on fundamental rights while martial law is in force in any area within the territory of India. It empowers the Parliament to indemnify any government servant or any other person for any act done by him in connection with the maintenance or restoration of order in any area where martial law was in force. The Parliament can also validate any sentence passed, punishment inflicted, forfeiture ordered or other act done under martial law in such area. The act of indemnity made by the Parliament cannot be challenged in any court on the ground of contravention of any of the fundamental rights. The concept of martial law has been borrowed in India from the English common law. However, the expression, martial law, has not been defined anywhere in the Constitution. Literally, it means military rule. It refers to a situation where civil administration is run by the military authorities according to their own rules and regulations framed outside the ordinary law. It does imply the suspension of ordinary law and the government by military tribunals. It is different from the military law that is applicable to the armed forces. There is also no specific or express provision in the Constitution that authorizes the executive to declare martial law. However, it is implicit in Article 34 under which martial law can be declared in any area within the territory of India. The martial law is imposed under the extraordinary circumstances like war, invasion, insurrection, rebellion, riot or any violent resistance to law. Its justification is to repel force by force for maintaining or restoring order in the society. During the operation of martial law, the military authorities are vested with abnormal powers to take all necessary steps. They impose restrictions and regulations on the rights of the civilians, can punish the civilians and even condemn them to death. The Supreme Court held that the declaration of martial law does not ipso facto result in the suspension of the writ of habeas corpus. The declaration of a martial law under Article 34 is different from the declaration of a national emergency under Article 352. The differences between the two are summarized in Table 7.3. Affecting certain fundamental rights. Article 35 lays down that the power to make laws, to give effect to certain specified fundamental rights shall vest only in the Parliament and not in the state legislatures. This provision ensures that there is uniformity throughout India with regard to the nature of those fundamental rights and punishment for their infringement. In this direction, Article 35 contains the following provisions. 1. The Parliament shall have, and the legislature of a state shall not have, power to make laws with respect to the following matters. I. Prescribing residence as a condition for certain employments or appointments in a state or union territory or local authority or other authority. Article 16. B. Empowering courts other than the Supreme Court and the High Courts to issue directions, orders and writs of all kinds for the enforcement of fundamental rights. Article 32. C. Restricting or abrogating the application of fundamental rights to members of armed forces, police forces, etc. Article 33. D. Indemnifying any government servant or any other person for any act done during the operation of martial law in any area. Article 34. 2. Parliament shall have, and the legislature of a state shall not have, powers to make laws for prescribing punishment for those acts that are declared to be offences under the fundamental rights. These include the following. I. Untouchability. Article 17. B. Traffic in human beings and forced labour. Article 23. Further, the Parliament shall, after the commencement of the Constitution, make laws for prescribing punishment for the above acts, thus making it obligatory on the part of the Parliament to enact such laws. 3. Any law in force at the commencement of the Constitution with respect to any of the matters specified above is to continue in force until altered or repealed or amended by the Parliament. It should be noted that Article 35 extends the competence of the Parliament to make a law on the matters specified above, even though some of those matters may fall within the sphere of the state legislatures, i.e., state list. Present position of right to property. Originally, the right to property was one of the 7 fundamental rights under Part 3 of the Constitution. It was dealt by Article 19, 1, F, and Article 31. Article 19, 1, F, guaranteed to every citizen the right to acquire, hold and dispose of property. Article 31, on the other hand, guaranteed to every person, whether citizen or non-citizen, right against deprivation of his property. It provided that no person shall be deprived of his property except by authority of law. It empowered the state to acquire or requisition the property of a person on 2 conditions. A. It should be for public purpose, and B. It should provide for payment of compensation, amount, to the owner. Since the commencement of the Constitution, the fundamental right to property has been the most controversial. It has caused confrontations between the Supreme Court and the Parliament. It has led to a number of constitutional amendments, that is, 1st, 4th, 7th, 25th, 39th, 40th and 42nd Amendments. Through these amendments, Articles 3.1a, 3.1b and 3.1c have been added and modified from time to time to nullify the effect of Supreme Court judgments and to protect certain laws from being challenged on the grounds of contravention of fundamental rights. Most of the litigation centered around the obligation of the state to pay compensation for acquisition or requisition of private property. Therefore, the 44th Amendment Act of 1978 abolished the right to property as a fundamental right by repealing Article 19, 1, F, and Article 31 from Part 3. Instead, the Act inserted a new Article 300 in Part 12 under the heading, Right to Property. It provides that no person shall be deprived of his property except by authority of law. Thus, the right to property still remains a legal right or a constitutional right, though no longer a fundamental right. It is not a part of the basic structure of the Constitution. The right to property as a legal right, as distinct from the fundamental rights, has the following implications. I. It can be regulated, i.e., curtailed, abridged or modified without constitutional amendment by an ordinary law of the Parliament. B. It protects private property against executive action but not against legislative action. C. In case of violation, the aggrieved person cannot directly move the Supreme Court under Article 32, right to constitutional remedies including writs, for its enforcement. He can move the High Court under Article 226. D. No guaranteed right to compensation in case of acquisition or requisition of the private property by the state. Though the fundamental right to property under Part 3 has been abolished, the Part 3 still carries two provisions which provide for the guaranteed right to compensation in case of acquisition or requisition of the private property by the state. These two cases where compensation has to be paid are A. When the state acquires the property of a minority educational institution, Article 30, and B. When the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limits, Article 31A. The first provision was added by the 44th Amendment Act, 1978, while the second provision was added by the 17th Amendment Act, 1964. Further, Articles 31A, 31B and 31C have been retained as exceptions to the fundamental rights. Exceptions to fundamental rights. 1. Saving of laws providing for acquisition of estates, etc. Article 31A(16) saves 5 categories of laws from being challenged and invalidated on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, and Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. They are related to agricultural land reforms, industry and commerce and include the following: A. Acquisition of estates 17 and related rights by the state. B. Taking over the management of properties by the state. C. Amalgamation of corporations. D. Extinguishment or modification of rights of directors or shareholders of corporations. And E. Extinguishment or modification of mining leases. Article 31A does not immunize a state law from judicial review unless it has been reserved for the President's consideration and has received his assent. This article also provides for the payment of compensation at market value when the state acquires the land held by a person under his personal cultivation and the land is within the statutory ceiling limit. 2. Validation of certain acts and regulations. Article 31B saves the acts and regulations included in the 9th Schedule 18 from being challenged and invalidated on the ground of contravention of any of the fundamental rights. Thus, the scope of Article 31B is wider than Article 31A. Article 31B immunizes any law included in the 9th Schedule from all the fundamental rights whether or not the law falls under any of the 5 categories specified in Article 31A. However, in a significant judgment delivered in I.R. Coelho, Case 18A, 2007, the Supreme Court ruled that there could not be any blanket immunity from judicial review of laws included in the 9th Schedule. The court held that judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th Schedule. It said that the laws placed under the 9th Schedule after 24 April 1973 are open to challenge in court if they violated fundamental rights guaranteed under Articles 14, 15, 19 and 21 or the basic structure of the Constitution. It was on 24 April 1973 that the Supreme Court first propounded the doctrine of basic structure or basic features of the Constitution in its landmark verdict in the Kesavananda Bharati Case 19. Originally, in 1951, the 9th Schedule contained only 13 acts and regulations, but at present, in 2016, their number is 282.20 of these. The acts and regulations of the state legislature deal with land reforms and abolition of the zamindari system, and that of the parliament deal with other matters. 3. Saving of laws giving effect to certain directive principles. Article 31C as inserted by the 25th Amendment Act of 1971 contained the following 2 provisions. A. No law that seeks to implement the socialistic directive principles specified in Article 39, B. 21 or C. 22 shall be void on the ground of contravention of the fundamental rights conferred by Article 14, equality before law and equal protection of laws, or Article 19, protection of 6 rights in respect of speech, assembly, movement, etc. B. No law containing a declaration that it is for giving effect to such policy shall be questioned in any court on the ground that it does not give effect to such a policy. In the Kesavananda Bharati Case 23, 1973, the Supreme Court declared the above second provision of Article 31C as unconstitutional and invalid on the ground that judicial review is a basic feature of the Constitution and hence cannot be taken away. However, the above first provision of Article 31C was held to be constitutional and valid. The 42nd Amendment Act, 1976, extended the scope of the above first provision of Article 31C by including within its protection any law to implement any of the directive principles specified in Part 4 of the Constitution and not merely in Article 39, B, or C. However, this extension was declared as unconstitutional and invalid by the Supreme Court in the Minerva Mills Case 24, 1980. Criticism of fundamental rights. The fundamental rights enshrined in Part 3 of the Constitution have met with a wide and varied criticism. The arguments of the critics are: 1. Excessive limitations. They are subjected to innumerable exceptions, restrictions, qualifications and explanations. Hence, the critics remarked that the Constitution grants fundamental rights with one hand and takes them away with the other. Jaspat Roy Kapoor went to the extent of saying that the chapter dealing with the fundamental rights should be renamed as Limitations on Fundamental Rights or Fundamental Rights and Limitations Thereon. 2. No social and economic rights. The list is not comprehensive as it mainly consists of political rights. It makes no provision for important social and economic rights like right to social security, right to work, right to employment, right to rest and leisure, and so on. These rights are made available to the citizens of advanced democratic countries. Also, the socialistic constitutions of erstwhile USSR or China provided for such rights. 3. No clarity. They are stated in a vague, indefinite and ambiguous manner. The various phrases and words used in the chapter like public order, minorities, reasonable restriction, public interest, and so on are not clearly defined. The language used to describe them is very complicated and beyond the comprehension of the common man. It is alleged that the constitution was made by the lawyers for the lawyers. Sir Ivor Jennings called the Constitution of India a paradise for lawyers. 4. No permanency. They are not sacrosanct or immutable as the parliament can curtail or abolish them, as for example, the abolition of the fundamental right to property in 1978. Hence, they can become a play tool in the hands of politicians having majority support in the parliament. The judicially innovated doctrine of basic structure is the only limitation on the authority of parliament to curtail or abolish the fundamental right. 5. Suspension during emergency. The suspension of their enforcement during the operation of national emergency, except Articles 20 and 21, is another blot on the efficacy of these rights. This provision cuts at the roots of democratic system in the country by placing the rights of the millions of innocent people in continuous jeopardy. According to the critics, the fundamental rights should be enjoyable in all situations, emergency or no emergency. 6. Expensive remedy. The judiciary has been made responsible for defending and protecting these rights against the interference of the legislatures and executives. However, the judicial process is too expensive and hinders the common man from getting his rights enforced through the courts. Hence, the critics say that the rights benefit mainly the rich section of the Indian society. 7. Preventive detention. The critics assert that the provision for preventive detention, Article 22, takes away the spirit and substance of the chapter on fundamental rights. It confers arbitrary powers on the state and negates individual liberty. It justifies the criticism that the Constitution of India deals more with the rights of the state against the individual than with the rights of the individual against the state. Notably, no democratic country in the world has made preventive detention as an integral part of their constitutions as has been made in India. 8. No consistent philosophy. According to some critics, the chapter on fundamental rights is not the product of any philosophical principle. Sir Ivor Jennings expressed this view when he said that the fundamental rights proclaimed by the Indian Constitution are based on no consistent philosophy. 25. The critics say that this creates difficulty for the Supreme Court and the High Courts in interpreting the fundamental rights. Significance of fundamental rights. In spite of the above criticism and shortcomings, the fundamental rights are significant in the following respects. 1. They constitute the bedrock of democratic system in the country. 2. They provide necessary conditions for the material and moral protection of man. 3. They serve as a formidable bulwark of individual liberty. 4. They facilitate the establishment of rule of law in the country. 5. They protect the interests of minorities and weaker sections of society. 6. They strengthen the secular fabric of the Indian state. 7. They check the absoluteness of the authority of the government. 8. They lay down the foundation stone of social equality and social justice. 9. They ensure the dignity and respect of individuals. 10. They facilitate the participation of people in the political and administrative process. Rights outside Part 3. Besides the fundamental rights included in Part 3, there are certain other rights contained in other parts of the Constitution. These rights are known as constitutional rights or legal rights or non-fundamental rights. They are: 1. No tax shall be levied or collected except by authority of law, Article 265 in Part 12. 2. No person shall be deprived of his property save by authority of law, Article 300 in Part 12. 3. Trade, commerce and intercourse throughout the territory of India shall be free, Article 301 in Part 13. Even though the above rights are also equally justiciable, they are different from the fundamental rights. In case of violation of a fundamental right, the aggrieved person can directly move the Supreme Court for its enforcement under Article 32, which is in itself a fundamental right. But, in case of violation of the above rights, the aggrieved person cannot avail this constitutional remedy. He can move the High Court by an ordinary suit or under Article 226, writ. Jurisdiction of High Court. Table 7.4 Articles related to fundamental rights at a glance. Article No. Subject matter. General. 12 Definition of state. 13 Laws inconsistent with or in derogation of the fundamental rights. Right to equality. 14 Equality before law. 15 Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. 16 Equality of opportunity in matters of public employment. 17 Abolition of untouchability. 18 Abolition of titles. Right to freedom. 19 Protection of certain rights regarding freedom of speech, etc. 20 Protection in respect of conviction for offences. 21 Protection of life and personal liberty. 21A Right to education. 22 Protection against arrest and detention in certain cases. Right against exploitation. 23 Prohibition of traffic in human beings and forced labor. 24 Prohibition of employment of children in factories, etc. Right to freedom of religion. 25 Freedom of conscience and free profession, practice and propagation of religion. 26 Freedom to manage religious affairs. 27 Freedom as to payment of taxes for promotion of any particular religion. 28 Freedom as to attendance at religious instruction or religious worship in certain educational institutions. Cultural and educational rights. 29 Protection of interests of minorities. 30 Right of minorities to establish and administer educational institutions. Right to property, repealed. 31 Compulsory acquisition of property, repealed. Saving of certain laws. 31A Saving of laws providing for acquisition of estates, etc. 3.1b Validation of certain acts and regulations. 3.1c Saving of laws giving effect to certain directive principles. 3.1d Saving of laws in respect of anti-national activities, repealed. Right to constitutional remedies. 32 Remedies for enforcement of rights conferred by this part. 3.2a Constitutional validity of state laws not to be considered in proceedings under Article 32, repealed. 33 Power of Parliament to modify the rights conferred by this part in their application to forces, etc. 34 Restriction on rights conferred by this part while martial law is in force in any area. 35 Legislation to give effect to the provisions of this part. Notes and references. 1. Magna Carta is the Charter of Rights issued by King John of England in 1215 under pressure from the barons. This is the first written document relating to the fundamental rights of citizens. 2. Keswananda Bharti vs. State of Kerala, 1973. 3. Dicey observe, no man is above the law, but every man, whatever be his rank or condition, is subject to the ordinary law of the realm and amenable to the jurisdiction of the ordinary tribunals. Every official from the Prime Minister down to a constable or a collector of taxes, is under the same responsibility for every act done without legal justification as any other citizen. A.V. Dicey, Introduction to the Study of the Law of the Constitution, Macmillan, 1931 edition p. 183191. 4. This second provision was added by the First Amendment Act of 1951. 5. By virtue of Article 371d inserted by the 32nd Amendment Act of 1973. 5a Article 371d has been extended to the state of Telangana by the Andhra Pradesh Reorganization Act, 2014. 6. The first Backward Classes Commission was appointed in 1953 under the chairmanship of Kaka Kalalkar. It submitted its report in 1955. 7. In 1963, the Supreme Court ruled that more than 50% reservation of jobs in a single year would be unconstitutional. 8. Indira Sohni v. Union of India, 1992. 9. The Tamil Nadu Backward Classes, Scheduled Castes and Scheduled Tribes, Reservation of Seats in Educational Institutions and of Appointments or Posts in the Services under the State, Act, 1994. 10. Balaji Raghavan v. Union of India, 1996. 10a The provision for cooperative societies was made by the 97th Constitutional Amendment Act of 2011. 10b Ibid. 11 A.K. Gopalan v. State of Madras, 1950. 12 Maneka Gandhi v. Union of India, 1978. 12a The Constitution, 86th Amendment, Act, 2002 and the Right of Children to Free and Compulsory Education Act, 2009 have come into force WEF 1st April 2010. 13 Originally known as the Suppression of Immoral Traffic in Women and Girls Act, 1956. 14 In this clause, the reference to Hindus shall be construed as including a reference to persons professing the Sikh, Jaina and Buddhist religion and the reference to Hindu religious institutions shall be construed accordingly. Article 25. 14 A Secretary of the Malankara Syrian Catholic College vs. T. Jose, 2007. 15 The second provision was added by the 15th Constitutional Amendment Act of 1963. 16 Added by the first Constitutional Amendment Act of 1951 and amended by the 4th, 17th and 44th Amendments. 17 The expression, estate, includes any jagir, inam, murfi or other similar grant, any janmam right in Tamil Nadu and Kerala and any land held for agricultural purposes. 18 Article 3.1b along with the 9th schedule was added by the first Constitutional Amendment Act of 1951. 18 Aya Koilhon vs. State of Tamil Nadu, 2007. 19 Keswananda Bharti v. State of Kerala, 1973. 20 Though the last entry is numbered 284, the actual total number is 282. This is because the three entries, 87, 92 and 130, have been deleted and one entry is numbered as 257A. 21 Article 39b says the state shall direct its policy towards securing that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. 22 Article 39c says the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. 23 Keswananda Bharti v. State of Kerala, 1973. 24 Minerva Mills v. Union of India, 1980. 25 Sir Ivor Jennings wrote, a thread of 19th century liberalism runs through it. There are consequences of the political problems of Britain in it. There are relics of the bitter experience in opposition to British rule, and there is evidence of a desire to reform some of the social institutions which time and circumstances have developed in India. The result is a series of complex formulae, in 24 articles, some of them lengthy, which must become the basis of a vast and complicated case law. T. 8 Directive Principles of State Policy. He Directive Principles of